My name is Heather Hui-Litwin, and joining me here is my colleague Heather Douglas. Today, we're going to talk about the duties of the court when they are hearing a case in front of one or more self-represented parties. Now, recently, there was an Ontario Court of Appeal case called Grand River versus Randus, in which this was discussed. But before I begin, I have a quick announcement. Litigation Help now has a shop, and Heather and I have prepared guides and templates for civil motions and for the Ontario Superior Court. So if you're a self-rep and you would like some help with filling out these civil motion court forms, be sure to check these out. And the link to access this is in the description box below. Okay, so now let's talk about the duties of the court. Heather, let me start by asking you, maybe just tell us a little bit about this case.
In the case, it was an appeal. One of the individuals involved was a self-represented litigant, and one of the questions was the adjournment that wasn't granted, was that problematic, and did the judge give the litigant a fair hearing? The court decided there was a fair hearing, but in doing so, made a few notes about what judges can do to also ensure in other cases that people have a fair hearing who are self-represented. So one of the things that they can do is to ask the litigant where they think the litigation is at, and to give them an opportunity to tell the court what their perspective of the lawsuit is. The second thing the judge can do is, in a motion or an application, allow the self-rep to give oral evidence, viva voce evidence, and to be cross-examined by the other side. That is not required. It's if the judge perceives that that would help the case in that specific matter. So don't go in expecting that you're going to have that privilege of giving live evidence in a motion or application. But if the judge finds that that would be the fairest way to handle the case, they are to swear the self-rep in and then allow the other side to cross-examine after that person has given their evidence. Another thing a judge can do is to kind of help the self-rep give the relevant information to the court, and maybe by asking some directed questions. Of course, a judge has to be careful to not go too far and veer into advocacy, but in appropriate cases, they can make sure that they have the right information by asking the relevant questions.
Right, thanks, Heather. Okay, so this case also mentioned that self-reps themselves have some duties. Can you elaborate a little bit on that as well?
Yeah, so self-reps, they need to familiarize themselves with the rules of the court, the procedures of the court, and the law that applies to their case. So just because you're self-represented doesn't mean that you're allowed to come unprepared to the court. You need to know your case, and you need to make sure to the best of your ability that you know the law and the rules of that apply to your case and the procedures. And the procedures refer to things like the rules of civil procedure, so the rules that govern how a hearing, how a proceeding should be.
Right, judges have to be impartial, so they cannot be biased for a self-rep or against a self-rep, for sure. And also, I just want to point out here that there are also duties for opposing counsel. So I'm going to have the links to these various excerpts in the description box below, so don't forget to check that out. Right, so thanks very much. Thank you everyone for watching. So if you're new to the channel, don't forget to hit the subscribe button and also hit that bell so that you'll be notified of our upcoming videos. And we'll see you the next time. Bye.
Bye.